Going on with this over here? Sarah, let's go ahead and bring in the first case.
Good morning.
Good morning. Mr. Wilson, if you would turn your camera on and unmute yourself. Mr. Wilson, if you would turn your camera on and unmute yourself, please. Mr. Wilson.
I'll see if I can call his office, Your Honor.
Thank you. Mr. Wilson, I see you unmuted yourself. Are you there? He must be having technical issues. Call his office. I'm going to go to the next case. I'll come right back to you.
Okay, thank you.
Let's go to Interbank. Sorry? Yeah, put them in the waiting room.
I don't have the
That's fine. Bring them in. If everyone could turn to their camera on and unmute themselves, please. We're on the record, 21 CCV 069164, Interbank USA versus Sohail Zaman. We're just here for a status conference. Can anybody give me an update on this bankruptcy that is pending, or if it's still pending?
Good morning, Judge. Attorney Krista Williams, representing the third-party defendant, Elias Haddad. From what we know, this bankruptcy is still ongoing. We received notice about 2 to 3 weeks ago that my client had switched bankruptcy attorneys, so I'm sure that's going to slow that process down a little bit more. We haven't received any notices of settlements or resolutions of any debt paid to the creditors.
And Judge, I the bankruptcy docket yesterday, and the plan's been filed, but there's no confirmation. That substitution was back in April or May. They've been filing, monthly operating reports, but it seems like at this point, it's either time for the defendant to go get the stay lifted if they do want to pursue the bankrupt defendant, or we just sever out those claims so that we can get this one moving along.
Okay.
There isn't any order that I saw in the bankruptcy proceeding that, has a confirmation deadline or anything else. It's been out there for about a year now, though.
Yeah, I think we received notice back in March of this year. So it's been pending a little while. Here's what I'm going to do. We need to figure out what's going on with this case. It just can't linger there forever. So I'm going to do a follow-up status conference in 60 days. After that, we need to have this thing kind of figured out where we're going. And hopefully the bankruptcy court has entered some sort of order finalizing the bankruptcy in one way or another. So
Yes, Judge.
we'll get a follow-up status conference. My coordinator will email y'all probably within the next couple of days once we get a date, and it'll be roughly 60 days out.
Thank you, Judge.
Thank you. Y'all are free to go.
Thank you, Judge.
Go back to number one. Wilson, are you there?
He said he could not hear us.
It is probably best if he disconnects and reconnects.
I think he did. He said he was going to do that.
He did. Mr. Wilson, are you there? All right, he's having some sort of technical issue on his end then at this point.
It just went
Tell
unmuted.
him, would you mind, Mr. Best, and would you mind reaching out to him one more time? Just tell him to find another computer or device of some sort to connect with. I mean,
Okay,
use his phone.
got it.
Fine. All right, and we'll come right back to you.
Okay.
Put him back in the waiting room. Let's move on. All right, bring in Mr. Banks. Make sure your microphone is turned on. Okay. All right, we're on the record, 24 CCVs.
Good morning, Your Honor. You're on mute.
No, I'm not. You should be able to hear me just fine. It's the way the system's set up. Can you hear me, Mr. Banks? Mr. Banks, can you hear me? About to do away with Zoom altogether. Mr. Banks, can you hear me? No more civil Zoom. We're done with civil motion Zoom.
Let me see if anything comes through this.
Sure, go ahead.
Testing, testing. Can you hear me, Elid?
Mr. Banks,
Your Honor, you're on mute.
no, I'm not.
Okay, I'm sorry.
Can you hear me?
when I'm looking at it on the screen, it shows that your mics are muted.
No. Turn your mic on, Sarah, see if you can't.
Can you hear me?
Mr. Banks, can you hear me?
Hello?
Mr. Banks,
Yes, I can hear you now.
you can hear me now. Okay.
Yes, Your Honor.
All right. We're on the record in 24 CCV 074714, the estate of James T. Young versus Quell Valley Townhouse Association. Let me get announcements from the attorneys, starting with plaintiff's counsel.
Good morning, Your Honor. My name is Olaide Banks. I'm here for plaintiff estate of James Young. The motions before the court today are our response to defendant's motion to quash and our motion to compel discovery and for in-camera review.
Shannon Lang on behalf of defendant, Quail Village Townhouse Association.
All right, we're going to start with the motion to compel. Mr. Banks, I'll give you a few minutes. I have read your motion to compel. I've read the exhibits attached. I've read the response as well to the motion to compel, but I'll give you a few minutes to make a brief argument.
Yes, Your Honor. Were you also able to receive the supplement? I filed that yesterday. There was a delay in e-file. I sent that to Ms. Tuller's email. Do you have that one as well?
No, I do not. If it was not in the file yesterday when I reviewed everything, it did not get reviewed. So proceed with what you have.
Okay, sure, Your Honor. Thank you. Well, we're here today in terms of the motion to compel. The primary things that we're looking at is there is at least one document that has not been produced. May I share an exhibit on the screen, Your Honor?
Let me set you up. Yes,
Sure.
okay, go ahead.
Okay. What we're sharing here, is this is on a motion to compel. There are a couple of things. One, and for in-camera review, this document that was produced by the defendant, it's of a board meeting, and as you can see here, it says the roof is fixed, and then there's redacted text around it. The date of the document is June 22nd, 2023. It's before this suit was on file. This is an example of what it is that we are looking at. There's something here. We're asking the court to review what defendant has redacted. Okay. There are also instances here in this email, okay? Showing you this big box right here. It's in the middle of an email, and it's going from a member of the HOA to the management company, and it's redacted in the middle of the document. It's not, as counsel indicated, where it's some kind of forward or something like that. I'm not asking to see it. I'm asking for the court to review it in camera and determine whether or not it's something that should be turned over. Additionally, counsel produced certain documents at the final deposition on September 11th. And those documents were documents we were asking for a long time, and they include estimates from one of the vendors, and they identify estimates number 4257, 4255, and then another estimate 42 4265, which is they produced 4265 and 4257. Now, in the email chain produced by defendant, it shows that 4255 was in their possession. There was also an email going back from defendant's representative, Iso Campo, saying, hey, that's for work inside the unit. We believe that that document supports our claim of damages within the unit, and we're asking them to produce that document. That's 4255. They produced 4265, 4257, but they have not produced 4255, which, as you see here, and documents that they produced, it was emailed to them. Okay. And other documents that they hadn't produced, we're asking that, they would be precluded from them presenting them at trial under 193.7. And we're just asking, so with respect to this motion, the motion to compel and the motion for in-camera review, we're asking for the court to review the items that they've redacted. They haven't provided a privilege log. They've indicated that they're not required to provide one. But we're saying, we're asking the court to review to see whether or not it should actually be redacted and kept away from us.
Mr.
And
Banks,
so that,
motion,
yes, Your Honor.
in your motion, you indicate under the request for documents that were failed to be produced and the request for production, you indicate a lot more than just the estimate 4255.
Yeah, there are a lot of those other documents. They hadn't produced them, but what I'm saying is, I've provided a supplement. If they hadn't produced them, I mean, there are a lot of things that, like in terms of estimates and other things like that. If they hadn't produced them, I'm saying that the sanction, not even the sanction, the rules say they can't later come up with them at trial. They still hadn't, they're saying in their last statement, hey, we don't have any of these documents.
Correct.
I'm not here to say that they're liars. I'm here saying now I've refined it. The discovery period is closed. I'm saying, give me the document that I know you have, and then have the judge look at what was redacted on that very important document.
Okay. So
Yeah.
all you want from them is this 4255. Of course, it goes without saying almost, if they don't produce it, they don't get to show it at trial. I mean, that's just basic understanding. So, all right.
But one more thing, I'm sorry, I don't mean to. The issue with not being able to 4255 goes against their interest. It's an estimate of damage within my client's unit. Okay. And so it's a third party that they hired that said, hey, this is what we need to do inside the unit. Now, if they're not producing it, yes, they can't produce it, but it's against their interest.
Okay.
Yeah.
Yeah, so I don't have any control over how JT Babylon names PDFs, but the two documents highlighted here have been produced. And I don't know what Mr. Banks is talking about estimates of interior damage. We produced an
Well, hold on, Ms. Lang. The document that's labeled estimate _ 4255 _ 2023-05-18-1.pdf. You're saying that it was produced. Can you tell me which document it was that you produced and provide the bait stamp number?
Yeah, if he scrolls down, it's one of the two invoices that he just showed. The two invoices are the two invoices that were attached to that email chain.
No, Your Honor. Let me tell you. So this invoice here says,
Mr. Lang.
Mr. Banks, I'm sorry.
I'm Mr. Banks. Mr. Banks, I'm sorry. My apologies.
Okay, I don't.
Hold on. One at a time. I'm going to give you an opportunity to respond to anything she says after she's completed. Okay, her response to you. Okay, so
I apologize, Your Honor.
just wait a few minutes. Thank you for scrolling down. You're saying 425 is which one?
Well, this says 4257. I don't have in front of me what the other one is. I do actually. But it's one of the other of those because those were the documents that were attached to the email.
There's 4265. So you're saying it's that one?
It must be that one.
No, it's not a must. It's either yes or no.
Yes. it's, but well, I mean, it's one or the other, because the two documents on that PDF are the two documents that we produced with the associated email chain.
Okay.
And with respect to, and when you read the email chain, both of the estimates are described in the text as repairs if you're going to extend the roof, or repairs if you're going to extend a drain in a patio. I don't know what he's talking about interior damage. The association doesn't.
And I have a question about that. Mr. Banks.
Yes, Your Honor.
I'm going to jump back to you, and I apologize to cut you off, Ms. Lang, but this is a pressing question on this whole issue. You claim that this 4255 estimate, it goes against their interest and talks about the interior damage to your client's unit, correct?
Yes, Your Honor.
Okay. How do you know that without having the document in hand?
Because it says so on the email chain. So let me show you that there's a separate email that here's the chain that they provided, and there's a separate email with a different date that attaches this document that's labeled 4265. This document here was sent on April 26th and is valid until 5/26. You'll see a separate email that they provided up here, which I'm showing you. It shows 4257 and 4255. So there's a separate email with a separate document,
Okay.
right?
I understand the attachment. Where in the email does it discuss that? About the damage to the interior unit and what needs to be done to fix the damage? Show
Okay,
me.
right here on April 18th, I'm showing you on the screen. This is Issa Ocampo saying to JT Babylon. So the initial email was sent on April the 8th. It's April, something like that. It's all mixed up. But here it says, also, can you clarify why the scope of work shows as interior work? What we need to address is the drain and the atrium. For your reference, I'm referring to this, that, and the other. Okay? So this email says, after they got the initial email, the Issa Ocampo on the 18th says, hey, why is the scope of work showing interior work for the other invoice that you sent? Then they sent this invoice right here, 4265. I didn't change it.
Yeah, I understand. Can you scroll back up just for a second?
Sure.
Keep going, keep going. Stop right there. The
Sure.
language under. What is the language underneath here where it looks like here's the body of the text above at the top of that page, and then you have what looks like a scanned document, maybe? What is that?
It looks as if this is this is from a report. I'm guessing this is from an excerpt from a report that I'll take you up that I've received, where there's a company called JRG Construction came in and identified the causes of the water intrusion, right? And this seems like an excerpt of that piece that they sent to this other company, GT Babylon, or Babylon GT Construction.
Okay. All right, and you're certain in this email that you're referencing right here on the screen, where they discuss interior work, is referencing the 4255 invoice or estimate, excuse me.
Well, yeah, because then the reason why I logically come to that conclusion is because they send initially 4257 and 4255, right? That are effective until 5/18, 1 month out. Then what council provided to me, and then we see a later email that sends 4265 that's valid until May 26th, right? So it's another 8 days later. If you look at the documents that were provided, there's the 4265 that references this date right here. And then there's the 4257 that references this same date right here. So logically, that says to me there's another document.
Okay. Ms. Lang, I'm going to go back to you.
Yeah, I've asked, I just emailed the client again and asked them to look again, but I'm told that they have searched high and low and every document touching on this property has been
Do
located.
they not have access to that email?
I've asked them to send it to me again. I got the chain that has these two documents attached. If we've got it, we'll produce it. I have asked for them to look for it. I just emailed them and asked them again.
I mean, because logically he is correct. I mean, it makes sense. So he's got 4.2,
Yeah.
the other two. I mean, you're 4.256 or 4.265 and 4.257. All right. Okay, so let's proceed with that. Well, I want you to search high and low because it looks like it's in your possession.
Yeah, I've already emailed the management company and asked them to look again. And if we get it, they respond to me every, daily. So if we have it, I'll turn it over today.
All right, Ms. Lang, I'm going to go now back to you again. And with regards to the redactions, we're going to switch.
So they've been complaining about the redactions on top of emails, like when someone forwards something to you from a client, they comment on it, we just redact the top, forward it on, nobody ever complains. With these, he asked during a deposition about the redactions on those board minutes. You can see there's a little arrow pointing to the issue underneath the issue on 12 Barcelona. It was explained during deposition that those are comments from the lawyer about a different issue. But, I'll log that if he needs another log for it. But we've clarified that these are things that say the lawyer then told us, or the lawyer.
And what do you mean you clarified? So how did you clarify with him? Did you send an email saying such
It was
or
brought up during a deposition?
brought up
And
during
the client said,
deposition?
you can see the arrow there that says that this is about something else. But I thought he was complaining about the emails, but if he needs a log, we'll give him a log. It's 2 documents.
So to be clear, Your Honor, I am looking at the very minimum, this 496, right? Where, again, it's covered up right here. And I'm asking for the court to review it. If it's privileged, I'm not asking to see it. It's either going to be privileged or not, right? Then in the middle of this document, middle of this email, this is not some header it's the middle of the text. Yeah.
I don't even see an email addressed to a law firm on there.
Yeah.
Yeah, before you've been complaining about different emails, but I'll log those, or I'll give them to you. There's nothing.
I mean, technically you don't have to provide a log. You just have to state in the response, that it's privileged essentially. And if it's obvious on its face, you have to do nothing because there's an exemption under there. Okay.
Yeah.
All right. So she's going to provide you a log outlining the privilege that she's asserting and a basic description without disclosing the communication of what it states.
Sure.
And it's just these 2 documents that you're seeking information.
Yeah, I mean, there these others. I have to take out her face. Like, yeah, those are the documents. The things where, if they're forwarding it seemed as if what they did is they redacted the dates where they forwarded to the law firm, because these documents are supposed to be produced back in March. It's from some of the documents, it seems like they send them to the law firm on July 1st and whatever. I don't care about that. I'm saying this one, there's text under here that's clearly related to this text, right? And so from my perspective, a privilege log is not going to be sufficient.
Mr. Banks,
Yes.
you do not have to go into explanation. I just want to clarify that all you're seeking are these 2 documents to be logged and outlined as to what they may state without disclosing what they're stating.
Correct. And but I'm asking for in-camera review of this document in particular. 496.
Because you're claiming that they're not that the privilege is incorrect of which they're stating?
Yes, yes. This was before in litigation. There was no pending litigation here. This is July 22nd, 2023. Our lawsuit was filed a year later.
Judge, I'm happy to show it to you. There's a little arrow right there because Monarch was their landscaping company that they were reviewing contracts and having some issues with. That's
have
what
it
the
with you?
objection is. I don't. I can email my staff and have them send me a copy of it right now. But like I said, we already told him this. But I can get someone to send it.
Send it over real quick.
Okay.
We're gonna make this happen today, because I'm not gonna let this sit on my desk and I have to worry about this later this week. So, Mr. Banks, Ms. Lang, I'm gonna put this case on hold. I'm gonna go take care of a few other cases. When you get it, send it to my coordinator. She's gonna print it out and give it to me right here so I can take a look at it, and then I'll bring you back in. Mr. Banks, we're gonna put you back in the waiting room for now, okay?
Thank you.
We're in recess on this case. You can step out. Let's go back to custom fit pools. All right, Mr. Basden, can you hear me?
I can.
Mr. Wilson, can you hear me?
I can hear you, Your Honor.
I just can't see you.
Yes, sir. I think what happened was my camera was interfering with my ability uh, on the audio. Excuse me. I'm sorry.
Okay. And there's no way you can turn your video on?
My internal camera is broke, so I bought another camera and put it in there. When I did have it in there earlier today, I think that must have been what was interfering with my ability to make you hear me, and so I can try again if you wish, but I just don't.
You
think
know
that
what? Let's not bother. Although I do have to, this whole scenario reminds me of that video from back during the pandemic when the one lawyer was saying, I'm not a cat or whatever it was. Because all I see is the Golden Gate Bridge.
Yes, sir. That is my background, Your Honor.
Okay, let's go ahead and get started. We're on the record in 19 CCV 065329. Custom Fit Pools versus Samantha Tabarez, Manuel Tabarez, also known as Ernie Tabarez. All right, we're here just to get this judgment figured out. I know we've got some objections as to the proposed judgment. Mr. Basden, you submitted an amended final judgment the other day, correct?
Correct.
All right, that's what I have in front of me. And is there an objection to this amended final judgment?
There is, Your Honor.
Okay, proceed with your objection quickly.
It's the same objection as before, Your Honor. I object because, number one, there is no evidence other than the $5,869.24 in attorney fees, and so the jury verdict of $10,000 is not supported by the evidence. That's the first one. The second one is that the damages that the jury found are not supported by the evidence in this case because they never ever showed what actual damages they had. What they said was, gee whiz, we'd like $10,000, and that's what the jury gave them. But there is no evidence to show what those damages were. And finally, Your Honor, again, I'm going to go back and saw on this same old horse. When they initially filed this case or brought this case up from the JP court, their initial pleading was, we want $10,000 plus attorney fees. And that, Judge, excludes jurisdiction because, as the court well knows, at that time, jurisdiction was $10,000. When you say $10,000 plus attorney fees, you pledge yourself out of jurisdiction. And even their own case that they submitted says that. So I don't believe that the court has jurisdiction because they asked for more than what the justice court had by way of jurisdiction. If you look at their original, if you look at the original answer and counterclaim that was filed in this case, you will see that what it says is we want $10,000 plus attorney fees. And even if that's only $1, Your Honor, that's more than the jurisdictional limits of the court, and therefore the court doesn't have jurisdiction. That's all I have, Judge.
Thank you. Mr. Madison.
So, Your Honor, we filed a plea.
Response.
Yeah.
I've read it, but go ahead and present your argument.
Well, I mean, that is the argument. What's in that pleading, essentially dealing with those issues. I guess let me talk about the attorney's fees real quick first. So the testimony was basically, I put into evidence the bills that had already been paid. And then I talked to one of my clients while she was on the stand about, you know, what we had done in front of the jury, essentially the time we had spent there. So they had the jury had all the information to make a calculation for the attorney's fees for the cost of trial. So I submit that their number was based on calculation they performed based on knowing what we had done, even though there's really no way to have a running bill to submit into evidence in a situation like this. And so the jury did what jurors do. They take the hourly rate, determine how much time we spent there based on the testimony of, I think it was Samantha that I talked to about that, Tabarez, that essentially got them to that $10,000 number. So I think there's plenty of evidence in the record to support that number. With respect to the damages piece, the $6,000, I mean, there is evidence in the case that the jury used to determine what the outstanding damages are as it relates to the pool for the repairs, because we had estimates for those things. We had estimates for the yard, various things. I agree. I don't know how they calculate $6,000 specifically, but they had plenty of evidence to support an award of damages of $6,000. So there's not a lack of evidence in support of that damage number either. So, and then finally on this issue of what the jurisdictional limit of the court is, there are cases that deal with that. And we kicked this around a lot in the courtroom back in the day because Mr. Wilson kept bringing it up and during the trial and knew then, I believe, that these cases existed that said that once if the case comes out of the JP court and you hire a lawyer, you're entitled to recover attorney's fees in those situations.
Okay. Any rebuttal?
Yes, Your Honor. The defendant in this case submitted a case called Tucker versus Pac Van Inc., which specifically says that if you plead for any money over the jurisdictional limit, you are out of jurisdiction. On page 2 of the case, when a case originally filed in JP court is appealed to the county court appellate jurisdiction is restricted to the jurisdictional limit of the JP court because a county court has no jurisdiction over the appeal unless the JP court has jurisdiction. And because they pled for $10,000 plus attorney fees, that is in excess of the jurisdictional limit of the court, of the JP court, and therefore this court does not have jurisdiction over this case. It's fairly black letter law. It doesn't have anything to do with how long it is or anything else. This is the day they filed the original counterclaim in your court, sir.
Okay. All right. Anything further, Mr. Wilson?
No, Your Honor, that'll do.
All right. Thank you. So I'm going to go ahead and sign off on the amended final judgment, approving essentially the jury's verdict. And I'm going to file it with the clerk's office at this point in time. Y'all can take these issues up on appeal.
Thank you, Your Honor. May we be excused?
Yes, you may.
Thank you.
Thank you, Your Honor.
Thank you. Let's go to the motion to reinstate. All right, give me a minute. Let me make a docket entry. When were they noticed to the hearing? Mm-hmm. Sarah, I'm looking at this email. Where's the date on it? Okay. So it was sent on 9/23. Okay, it's denied. Have you received an email?
I just forwarded that document.
Run it when you got it. Mm.
Showing it is. Sarah.Toller@FortBend County TX.gov.
Donati? Bring him in. Mr. Donati? You're muted first off, so I can't hear you. But secondly, the matter is rescheduled for a follow-up status conference in 60 days to see where the bankruptcy stands at that time.
Okay, thank you.
Receive an email from my coordinator giving you the date and time of that hearing.
Okay, thank you.
All right, you're free to go.
Thank you, sir.
Well, that ain't gonna work.
Judge, if it helps, Jessica is an attorney in my office, and the notes on the side, we were at this, are notes related to another issue.
Let's not get it. Been bringing it. All right, we're on the record in 24 CCV 074714, the estate of James T. Young versus Quail Valley Townhouse Association. Present is Attorney Banks and Attorney Lang. All right, so I finally received this first document. It's the QVI HOA workshop agenda from June 22nd, 2023 at 6 p.m. The portion that was blacked out, that was redacted. Ms. Lang, can you shed some light as to whose handwriting this is?
Client, board member. The comments in there regarding Jessica are comments to and about a lawyer in my office. And the comments on the side are reflecting discussions that were had at the time regarding another item on the agenda. But I think this was one of the male board members' handwriting, but I couldn't say for sure.
It'll be disclosed.
Thank you, Your Honor.
An unredacted version will be disclosed. Wasn't there another email that you were concerned about, or were you not concerned about that email, Mr. Banks?
Yes, Your Honor. The email that I was concerned about, here it is. It's right here. Email July 17th is from Tara Hirsch, Houston HOA to, yeah.
Hold on. I don't have that, Miss Lang. Did you send that?
No, not that one.
Okay, send it. While we're waiting on your associate to send that over to my coordinator, who will print it once it arrives. Let's go ahead and get into the motion to quash. I'll give you a moment to finish that text or email.
That was document number 391, Your Honor.
Thank you.
There's part of that was told.
Okay.
And then it's the second to the last page. And again, the reference to Jess is to the lawyer.
All right. Very good. I'll take a look at it in a second. Let's proceed with the motion to quash and the response as well. Go ahead, Ms. Lang.
Well, I didn't set this, but we got a notice of deposition for an employee of the management company at which isn't a party, and I don't represent any of the employees of the company. But there was a notice of deposition sent to have a employee of the association's management company appear in person in Houston for a deposition with a list of topics. We quashed because I don't represent her. I can't compel her attendance. She doesn't live in Texas, and she wouldn't ever be designated as a corporate rep anyway. My understanding is that Mr. Banks thinks I should somehow produce somebody else. I don't really understand the arguments, to be honest. He can depose anyone he wants. He just has to send subpoenas. I can't get someone to come here from the Philippines and show up here for a deposition. So we quashed it.
Mr. Banks?
Your Honor, so yeah, we requested the deposition of Isa Ocampo. She is a representative of the HOA. She's the agent. She's the primary point of contact. The information that she's in the Philippines, that was not. I mean, we didn't know that. We didn't know that she wasn't that she was in the Philippines. But the idea that the management company, which is an agent of the HOA, is not under their control. It's not consistent with the facts in the case. I'll show you just really quickly Exhibit A. Essentially, every communication with my client, with the front-facing contact that homeowners have with the board, with the HOA, is with this Isa Ocampo. Every message that's forwarded, every invoice, every single thing is forwarded through and by Isa Ocampo. And so we believe that she is indeed under their control, under the theory of agency.
Did you sue this Houston management or whatever the name of that is?
No, we didn't sue them because they're the agent of the HOA. The HOA is the one who has the duty. They have a management certificate on file. They act their actions with respect to the HOA.
Okay.
I mean, their actions with respect to the HOA are the actions of the HOA.
Go ahead, Ms. Lang.
Sure. Houston HOA Management LLC is the management company for the association. If there had been a request for a corporate rep from Houston HOA Management, maybe this would be different. But just as anyone who represents a company doesn't represent every employee of the company, I don't represent Houston HOA Management, and I don't represent their employees. I never said he can't depose Ms. Ocampo. I just can't get her to show up. That's why we quashed the deposition. He can subpoena whoever he wants, but I can't get someone's employee to show up from halfway around the world or from more than 150 miles outside of this jurisdiction. And that,
I mean, she's absolutely right, Mr. Banks. Why don't you just subpoena her?
By the time we got to this, we're outside of the discovery. I mean, we could subpoena to testify for trial. Again, subpoenaing somebody in the Philippines.
No, I get it. You're running up against a deadline at this point in
Yeah.
time. Route corner, and I mean, we're kind of late to the game when it comes to this whole matter of the motion to quash and the need to conduct a deposition. So, we're going to essentially grant the motion to quash. I'm going to grant it, and we're going to pursue. We're going to move on. You have that email, Sarah? Ms. Lang, can you please re-forward that email to my coordinator?
Maybe give him 15 seconds, Your Honor. I know you're granted it just as a matter of context.
I'm sorry, what now?
Can I get 15 seconds? I know you've already granted it. I'm not arguing against your grant of the motion to quash, but just a little bit of context.
A little bit of context of what from.
Okay, council asked when we were scheduling depositions, we discussed before, okay, which witnesses do you want, right? Okay,
We're going to stop right now.
stop, okay,
I've made my ruling.
got it.
Now I'm waiting on the email so I can figure out the redacted portion of it, if it will be disclosed or not.
Thank you, Your Honor.
Can you scroll up to the email so I can see exactly what was redacted?
Yes, Your Honor. I need to switch that email, sorry.
And Jess is an attorney with your office. And this is a communication between two HOA members. It'll be disclosed. You'll get an unredacted version.
Thank you, Your Honor.
Okay. I do believe that takes care of all matters for today that were noticed.
Yes, but there's one thing I was just hoping I could bring up. We took depositions late in the case. And the 30-day read and sign is gonna be after the trial in 2 weeks. Can we get an order to expedite that so we can use these depositions at trial? It would affect both parties. I've got one, I deposed his client like 2 weeks ago and just got the transcript. He deposed a board member the week before that, and the transcript was just circulated.
Did you hear that, Mr. Banks?
I heard it. I don't need the depositions. We have the documents.
Okay, well, we'd like to be able to use the deposition of his client, but we're not gonna get through the read and sign period of time. Because the transcript was just circulated, I think, on Friday.
That's fine. Just give me an order. And it will apply to both sides equally.
All right. Thank you, Your Honor.
Okay. That concludes today's hearing. Y'all are free to go.
Thank you, Judge.
All right. Thank you, Your Honor. And Your Honor, when will we get those documents?
Well, they'll be disclosed within 24 hours.
Thank you, Your Honor.
Thank you.
All right. Maybe excuse, Your Honor.
Yes, you may.
Thank you.